This last panel, it's not the last session, the closer is going to be Dave Cappo, so he'll give us his summary and impressions and suggestions. So it's hardly the last big event of the day. This last session, though, is one of the key reasons we've done this program, is really to talk about what the government can do, what its role is in promoting licensing, and what it shouldn't do for that matter. I think we heard a suggestion from Larry already. Mandating indemnities may not be the best thing. I would agree with that. And the way we've structured this panel is the narrative, if you will, is we're going to go from the international perspective down to the federal perspectives, to state and university perspectives, and finally, since I always felt like the thing I never advise people on is taxes. I always feel that when we talk about licensing and how to do deals and the role of the government, KPMG and Tyrone will chime in at the end about how to structure deals from a tax perspective and what the government can do using taxation to promote licensing and technology transfer. So we have a great panel, and we're pleased as well to have different perspectives. And we're going to begin with Matt Rainey from WIPO to talk about WIPO's role in this area.
Thank you, Mark. Let's see, does that work? Can people hear me? Please don't be shy about raising your hand or go like this, because I know what it's like trying to hear it down there. The topic here is government's role in promoting licensing. In the interest of full disclosure, I would like to say I am not a government. I don't work for a government. I work for WIPO, which is an intergovernmental agency, agency of the United Nations, World Intellectual Property Organization. Thank you very much. I'll appreciate that. And we, as an organization, do support licensing, IP transactions, IP systems around the world, but we don't do it the way a government would do it. A government can pass policies, can pass laws. Thank you very much. That's awfully kind of you. One of these buttons should do it. Can create infrastructure, can generate funding, can do a lot of things that a United Nations agency cannot do. For those of you who are not particularly familiar with WIPO, the organization manages the international IP treaties, such as the Patent Cooperation Treaty, the treaties for trademarks, Madrid, design law, etc. And I'm a patent attorney. I've been practicing patent law for most of my life, but I went to WIPO about 5 years ago. And now I'm in something called the WIPO Academy, which does look at these issues. How do we facilitate, train, and so on? So the way I picked out some, but not all of the ways that this intergovernmental agency supports licensing. We do training programs. We have publications. We have something called patent landscape reports. We have online resources with patents and technology information, and we have online resources specifically about licensing. So as an example, in the WIPO Academy, where I work, we have distance learning courses, quite a few courses which will introduce anybody who wishes to take them. Some of them are free, some of them are funded, or some of them are fee-based rather, from everything from introduction to many different topics around IP, including patent valuation, patent licensing, patent enforcement, and so on. We also have a professional development program, which is mostly for government employees. That's the target. But that has a trickle-down effect because they then pass the information on and use that information to enable whoever it may be in their separate countries to use the information for transfer of technology, for licensing, and so on. We actually cooperate with universities for joint master programs in IP around the world. And we have summer school programs, which are shorter programs around IP. So these are some of the mechanisms that the UN uses. In terms of subject matter, IP management is core to what we teach. I'm revising some of the programs right now. My job at the Academy as a patent attorney is to go through and propose new programs and to update the ones that are there. And so I'm doing that with some of these in particular. Patent drafting for the beginner, patent drafting advanced, patent enforcement. That's a big topic. Again, that's an area that governments, we have some governments here, but that's an area that governments can work in that IP, that WIPO can't particularly enable but can advise on. But we do some training in that. We do training on patent search and examination, valuation, licensing, and so on. The last one there, SMEs, is very important. Think small business. A lot of what our efforts are directed to is helping the small business, the individual inventor, make his or her way through the system of applying for patent applications and getting issuance and enforcing and licensing. We also have a great number of WIPO publications. You can access most of these, and you or your clients or people you are interested in supporting on all of these topics. So that's another area. WIPO landscape reports, patent landscape reports, are very in-depth looks at particular patent situations for particular technologies, maybe global, maybe regional, and we get these requests in. We can't do them all, but we've done quite a few of them in great depth, looking at the state of the art in particular patent areas, looking at the geographical spread, look at the depth of the technologies, and you can download these as well. And these will inform your analyses. These will support your licensing efforts. As an example, microalgae-related e-waste, visually and hearing impaired genetic resources. You can't read this eye chart very well, but if you access the list later on, you can actually go to these sites that are listed here and download these landscape reports. That's another way we do it. We have online resources. Just for a show of hands, how many people here have used PatentScope? Raise your hands. About 20%, 30%. I recommend you get on there. It's a very good tool. I'm not bragging just because it's WIPO, but I really enjoy using it. You can use it at a top level, or there are various ways of combining the fields and doing a fairly in-depth search worldwide. It'll access a lot of information worldwide that you won't get any other way. Of course, patent offices like the USPTO and others have their own databases as well, but I recommend this because of the international scope. You can also find webinars. You can find video tutorials. We have translation services. So there are a lot of services that WIPO can offer that support the efforts that you can't necessarily legislate these things, but we can provide the information. There's another one called ASPI, which is access to specialized patent information. It's mostly for developing countries, but that's most of the world. So that's a lot. RD is another one, access to research for development and innovation. 20,000 journals are available there. WIPO Green, and actually there's Sherry. You mentioned WIPO Research. There's another version of these slides that has WIPO Research mentioned. Thank you for mentioning it, and it didn't get in this one. Sherry already mentioned WIPO Research, which is not in the slides, but it's a resource for researching neglected tropical diseases, malaria, and tuberculosis in particular. And so it's an area to get both technology and, as Sherry mentioned earlier, know-how, which is very important. I think as anybody who's practiced patent law knows, the information is not all contained in the four corners of the patent application. There's a lot more beyond. WIPO Green is for green technologies in particular. WIPO Pearl is multilingual in 10 languages, so that's very helpful. And then there are particular so when you file a PCT application, I don't know how many of you do this, but you can check a box that says, I'm interested in licensing this application. and that goes into the PCT database. And then when you search on Patent Scope, you can limit your searches, or at least modify your searches, to include those that are available for licensing. So that's one way of connecting potential licensors with potential licensees. You can do the field combination search in many ways, but that's one of the attributes. And in addition, WIPO is cooperating with, in this particular case, the Danish Patent Office, which is, if you ever go to AIPLA meetings, you know they're there all the time. They're very active. They're very interested in reaching out internationally for searches. And we partner with them, and they have these IP Marketplace and IP Trade Portal websites, which the links are here. I really recommend you go look at them. In combination, Patent Scope and these sites give you a lot of information about what you can license. So those are the things that we do at WIPO. As I say, we can't legislate. We can advise countries. We can't enforce laws, but we can advise countries on how they might best use the international system to support licensing. And with that, I'll hand it over.
Thank you, Matt. Before we turn to Paul, just one quick question. You have a standard contract. Has WIPO ever looked at model contracts for licensing?
We do. And in fact, we have technology licensing seminars, week-long seminars, and we'll use model contracts. Model contracts, as we all know, have limited utility. I mean, I'll use one, and my background's physics and computers, that's entirely different from a pharma, type. So when I create these things, mostly I try to go by way of concept rather than an actual model contract. What's the term? What's the geographical distribution? Who's the sub-licensee, and so on. So there's a combination of things.
I guess the idea of any kind of treaty, like for licensing of technology, like there is for sale of goods, is probably a bit too arduous of an undertaking.
I think it would require too many assumptions about the details in the license to go anywhere.
Right, I agree with that. Okay, so our next speaker is, where is he? There he is. It's Paul Zielinski from a sister commerce agency, NIST. And we heard a bit about NIST from Bruce Andrews this morning, and we'll hear some more about federal licensing practices.
Hi, thank you very much for inviting me today. So I want to talk a little bit about the higher level on government-wide licensing from our federal laboratories. And in that regard, one of my roles right now is to serve as the chair of a thing called the Federal Laboratory Consortium for Technology Transfer, which, if you haven't heard of us, we're actually an organization that is a community of practice across all of the 300-plus federal laboratories across 11 different agencies that conduct research and development in the United States. And so we actually produce a good bit of information that we want to transfer out. My other role is actually to serve as the director of the Technology Transfer Office, called the Technology Partnerships Office at the National Institute of Standards and Technology. That also comes with some roles and responsibilities for the Department of Commerce in terms of coordinating some of the interagency effort, as well as reporting out the statistics on different areas in technology transfer across the government. So just at a very high level, why would federal laboratories want to license technology? Why would we even patent technology? It's interesting. I've even had a call from different competing senators in the same week, one of them insisting that we should not be stealing money from the American people by patenting and licensing technology for things that they've already paid for, versus another senator's office calling me and excoriating me for not charging enough royalties because we're stealing money from the American people by not getting the best return on investment from their tax dollars. And so you can look at this a lot of different ways. But the way we like to really look at it is sort of using this cartoon here, if you will, which is really very much to look at the government itself. We do a lot of research and development. We spend more than $130 billion a year right now on research and development across the federal system. We do a lot of things in the government. We regulate, we do all sorts of stuff. If you're in the Department of Defense or NASA, you buy a lot of things, particularly if you're in defense. But what we don't do is we don't make consumer products. Even if you're in the Department of Defense, if you think about like the F-22 Raptor, it's not made by the government. It's made by Lockheed and Boeing. And it's purchased by the federal government. So we actually have a great need to transfer that technology out to other parties. In a lot of cases, that takes the form of defining what that technology is in the terms of a patent so that we can transfer it to the private party to make, sell, distribute, all these other wonderful things, which takes private investment. Our goal is to get these things out of the government, which means we need someone else to pick up the tab for all these other things. That requires private investment. Oftentimes that requires a patent, that requires a license, that requires something that somebody can invest in. That's our interest in this area. This actually isn't available yet, but like I said, we actually produced the statistics on this. The 2014 report isn't out, but I thought I'd share this. In 2011, the president gave us a mandate to increase the commercialization of technology from federal laboratories. So we've been working very hard at doing that. The current form of that is actually called the Lab to Market Cross-Agency Priority Goal, and you can find that easily enough. But to give you some idea, we actually have done that. So this chart basically just takes the information and puts it into an index form looking at 2011, so you can see where we've increased our rate of patenting, and in fact, we've increased our rate of licensing. The third line you see there is actually a thing called CRADAs, Cooperative Research and Development Agreements, and we've increased the rate of that as well. And when you think about a CRADA in terms of licensing, they actually are related, and this gets back to the discussion you've heard all day about licensing know-how. We don't really do it that way. What we will do is we will license an invention, and then we can go ahead and follow up and do a Cooperative Research and Development Agreement to have that follow up with the know-how from the federal laboratory. So this chart gives you just sort of an idea of things that we license. And in fact, many of the things we license are not, in fact, patent licenses, but other types of things, biological materials, plant varieties, a whole bunch of, even in some cases, software from contractor-operated laboratories. But we do have a significant amount of patent licenses that we do each year. In fact, if you look at this, we were in the neighborhood of 400 to 500 new licenses each year, and in fact around 4,000 roughly active licenses across the federal system. So again, it's not our primary goal of transferring information. There's lots of different ways we transfer information, but it's an incredibly important way that we transfer things, particularly for areas that require private capital and investment. And that's one of the bigger reasons that we actually do this whole activity of patenting and licensing is, to get it out of the government paying for everything. You just had a big discussion about the cost of new drugs, for example, new pharmaceuticals. That has to be protected. There has to be some bounds to that so that people can get a return on investment. That's our interest in it. Again, the Federal Lab Consortium, as an organization, we don't actually do the licensing. It actually is each individual agency has their own procedures, but we can facilitate you getting to the right people and finding that, what inventions are available sort of as a one-stop shop, and that's the function that we serve from that. You'll hear a little bit more detail about how one agency does that later on in Mojdeh's presentation. So thank you. That's my contact information.
Paul, is that also true for you? Is it easier to tell stories than to tell numbers?
Well, we have a bit of both, but I think as Mojdeh was saying, when you look at numbers, income is not our biggest number, and that's probably one of the biggest things I would have to emphasize from the federal lab is that that's not our goal. Our goal is to transfer the technology, and the best wording of this actually comes from Congress, which is practical application. We want somebody to actually use it, make it. That's where the taxpayer gets their return on investment, is actually that there's a product or service in the marketplace that they can buy or use.
We talked earlier about the problems of SCOTUS decisions and U.S. law that seems to be weakening IP. I think Biddle is one of our positive exports that many other countries have picked up on and have tried to emulate. I know certainly in China it's the case, and I was privileged to be in China on Birchbai's 80th birthday at the Chinese Patent Office, and he was treated like an 80-year-old rock star. It was really something to see. So going from the federal government to the state level, we'll turn to Mike Remington to see what's happening in the Badger State.
Hello, is this on? Can you hear me? I'd like to start with a story. I liked your line about stories better than empirical evidence, but I don't want to diminish empirical evidence. I guess Dr. Rock Mackey from the Wisconsin Alumni Research Foundation could not be here due to an illness in his family. So I'd like to start with a story that he would have given about WARF, what we call it. 90 years ago, a professor at the University of Wisconsin, Harry Steenbach, started the Wisconsin Alumni Research Foundation in order to patent UW inventions and use the proceeds to benefit and help the university. He came up with an invention. He discovered that irradiation with ultraviolet light increased the vitamin D content of food. And at the time, rickets, a childhood disease, was a scourge, probably on a magnitude of Zika or other things. It wasn't bacterial or anything, but it was a dread disease for children. And so he came up with this invention to cure rickets. And he, at the time, universities thought that they shouldn't patent because it wasn't in the university mission of sharing research and development. And so he went out and got his own patent for $300. And a big company came to him and said, we'd like to license it. It was actually Quaker Oats. And we'd like to put this vitamin D compound in breakfast cereal. And they wanted to buy the technology. And the professor got together with some of his patent lawyer friends, and he said, well, I don't want to sell it. I'd like to license it, but we have to set up a foundation to do it. And so WARF was set up as a private, nonprofit foundation to manage patents. And that was done in 1925. The board's first action, the board was composed of all Wisconsin alumni. I'm sitting by one here, so you'd probably qualify for the board, and I would too. I don't know if we have any other Badgers. This is somewhat akin in Wisconsin to the Green Bay Packers owning the team. So Wisconsin alumni own and manage WARF. The first thing they did is they licensed it on a non-exclusive basis to Quaker Oats. And that created a royalty flow. One advantage of licensing is it's not a one-time sale. The revenues come in. And by the time the Steenbach patent went into the public domain, for all purposes, rickets had been wiped out as a disease. And WARF had money in its foundation. And the concept of licensing at UW-Madison was off and running, and a number of success stories came in the wake. Something called warfarin, now called Coumadin, which is a blood thinner, but started out as a rodenticide killer for rodents. It was given an award by India a number of years ago as the most important technology advancement in the world, and WARF got an award for that. Vitamin D, Dr. Mackey's 3D treatment planning system is the most widespread radiation therapy treatment in the world. I wish he was here to tell you about it. But year in and year out, UW-Madison has always been like a top 5 in terms of number of patents. And that's pretty good for a state that is between 25th and 30th in terms of population. WARF's endowment has grown to $3 billion, and it gives back roughly 4% of the corpus to the university to engage in what we call the ever cycle of innovation. So it will live on, and so that's my story about WARF. We're proud of it, and we think that it has served as a model for other universities. It's an outgrowth of the land grant and public university, and this is where the role of government comes in. You have to factor in the fact that a land grant university is a government role. Now, that's my first assignment, to talk about WARF, but I would like to talk a little bit about the government role in promoting licensing. And it's a pleasure to be here at the PTO. I was chief counsel of the House Judiciary Committee IP subcommittee for many, many years. Too long to tell you how many years, but I used to do the PTO budget, and those were in not the good old days. So it's a pleasure to be here. The Bayh-Dole Act actually was an outgrowth of a domestic policy review set up by Jimmy Carter. And for you older people, you might remember that that was not a real good time. We were getting our lunch handed to us by the Japanese. No offense to the Japanese, but they were beating us, and we had enormous inflation, and we had patents sitting on the shelves of government agencies. They were being patented, but they were never being brought or transferred to the public. And so the Carter administration had this idea of the Bayh-Dole Act, and it was actually enacted in 1980 during the lame duck session, and it was on the last day of that Congress. So, but the torch was passed immediately to the Reagan administration. Some referred to it as a revolution. And I'm telling you this story because we're living in sort of an unpredictable time today about whoever's elected president in the United States. Will this be a radical change or will this be a handoff? And I'm not taking positions, but it's historically interesting that the Carter administration, under the leadership of the Department of Commerce, didn't change much in terms of the Reagan people. The Bayh-Dole Act was amended in 1984, and it was actually enlarged in terms of the ability to license patents based on federal funding. The government laboratories were brought under the Bayh-Dole Act, and in 1986, by executive order, President Reagan enlarged the Bayh-Dole Act to apply to all businesses, not just small businesses and universities. So it's been proved to be a very successful statute. It is now under attack, like many elements of the Patent Act, and it does fit well with the fact that the largest source of R&D in the country is the federal government, and I would add that as a role of the government. We shouldn't take it for granted, but we invest more through taxpayer money than any other country in the world. Bayh-Dole is a template for how you handle the intellectual property in federally funded research. Bayh-Dole has some standards. Universities retain and nonprofits retain patent rights, but they're obligated to do certain things like commercialize inventions. Congress, we like to trash Congress, but I think Congress deserves a great deal of credit in terms of its role. It oversees Bayh-Dole. You do get questions coming from both sides, but the administration of the Bayh-Dole Act, agency up by agency, and I know NIST does a good job on this, is quite important. That's an important role itself. And it's returned, there's data on this. I won't go into it, but I would recommend that anybody who needs the data would go to the Autumn Licensing Survey, which is a wonderful source. A study of drugs recently discovered in public sector research an estimated global sales of $102 billion. The Biotechnology Industry Organization has done a report. Nonprofit patent licensing activity contributed $518 billion U.S. GDP and 1.1 trillion in U.S. gross industrial output. So I'm going to stop right now. I'd like to maybe address later some problems that have arisen that do require a government role to solve those problems. Thank you, Mark.
Thank you, Mike. Before we leave you, is the trend still towards licensing, or is it towards spin-offs? What's happening at the university level to commercialize technology?
Well, I look upon Bayh-Dole, the beneficiaries of Bayh-Dole, and this is a government role that people don't often think about, because state governments are the beneficiaries of Bayh-Dole. Why do I say that? Technology transfer increases jobs. if successful in a state. It increases the tax rolls, and it creates new companies, either startups or small businesses. Now, WARF is unique in the sense that it's private. It has a fund with a significant amount of money. It takes equity in startups, but you have to go state by state to see how universities are administering by dole. We're in good shape in Wisconsin because, and Dr. Mackey's tomotherapy company was invested in by WARF. So it's a hard question to answer. And I do know that the governors now are making these phone calls that Paul got saying, how many jobs have you created? What's the tax ramifications of federally funded research? And there's data on who's doing well and who's not doing well. And you just have to go state by state.
Great.
We think we're a model. We're a licensing model. But I would say that the University of California system is a model. University of Texas, Michigan, and some of the privates are models. But the private is a different way to approach it, too.
Okay, great. So we'll circle back a little later. If you make money, you usually have to pay taxes. There are exceptions. I've heard of a few recently who haven't been paying much in taxes. But what are the optimal ways that the government should tax innovation and licensing without hindering its development and contribution to society? We've heard a lot about different ways USDA, University of Wisconsin, and others have contributed, not just in financial terms. So we still want to encourage the innovation. And what's the perspective from KPMG?
Well, thank you, Mark. There are a number of credits. If you could pass me the clicker, please. There's a number of credits that Congress has created to basically say to the world, I want you, and you, and you, and you, and you to come to the United States and do your R&D here in the United States. The goal of these incentives is to attract and retain R&D jobs in the United States. These are all about the jobs because they're geographic in nature. The work needs to be done in the United States. It's a boots on the ground type analysis. The results can be exploited globally, but the work has to be done in the United States. So we want people to do their R&D here in the U.S. And there are other incentives as well. Even if you have a finished product and if you do your manufacturing here in the U.S., you can get an extra deduction for that. The top credit is the basic research credit, which is, in a nutshell, amounts paid to universities for research will be for the general betterment of mankind. A very nice credit. We run into that a little bit. The Energy Research Consortium credit came out in about 2005 when oil prices and gas prices and all energy prices seemed to be going through the roof. A nice 20% credit for Energy Consortium research. Interestingly, no base amount there. The research tax credit, the third one on my list, is my bread and butter. This is where many, many companies in the U.S. and foreign companies as well that do their R&D in the U.S. or portions of it really get a very nice benefit. There are a number of different technical aspects to the calculation, which we won't go into. But from a high level, it's a 20% gross rate if you're using what's called the regular credit. There's a 13% net rate. Again, won't get into the nitty-gritty details. But there's also an alternative simplified method. The big difference between the two, the regular credit, in some cases, believe it or not, you have to go back to those years that Michael was talking about with the Reagan administration, 84 to 88, and I guess maybe that was part of the Clinton administration too. So a lot of people don't have those records, so they'd rather use the alternative simplified credit, which generally looks at your current year and the prior 3 years. That's my bread and butter. My favorite credit, though, is the orphan drug credit. The orphan drug credit, in general, is for drugs to treat rare disease and conditions. This is, frankly, to do God's work, to help people who are suffering from different maladies where there might not be as much of an incentive to help cure them than would otherwise exist. There are some exceptions if there's no reasonable expectation of recovering your costs, but in general, if you affect less than 200,000 people, the orphan drug credit is available, and that is really just a wonderful thing. And there's also other benefits that go along with the orphan drug credit. There's exclusivity in selling the drug, and there's also an exemption from a branded drug prescription fee. A lot of things with the orphan drug credit that are not readily apparent, as well as state and local incentives, mostly states, but many states have their own R&D credit. Well, what industries claim these credits? Just about every industry you can think of can qualify for the R&D credit. And this is mostly because software development in certain cases can also qualify for the credit. So when you see up here the financial and insurance industry right there, 304. What do you think a bank or an insurance company is doing R&D wise? It's all about the software development. So just about every industry you can think of, 15,000, almost 16,000 claimants in 2012. That was the most recent year that the statistics were available. But these R&D credits are out there, and again, we want to attract and retain R&D jobs here in the United States. I talked a little bit about the two different methods, the regular research credit and the alternative simplified credit. As you can see, the ASC is now bigger than the regular research credit because trying to dig up records from 1984 to 88 and then factoring in acquisitions and dispositions thereafter, a lot of people say, hey, I can look at my current year and the prior 3, I'll do that. But total, that's almost $11 billion in R&D tax credits that have been claimed in 2012, the most recent year available. So there's big dollars in the R&D tax credit field. What if I'm a foreign company, though? Can I do R&D here in the United States? Yes, absolutely. We want the jobs here. But a lot of U.S. companies, subsidiaries of foreign parents say, well, you know, I'm getting reimbursed by my parent in X country, so I don't think I can qualify. Well, in most cases, as long as there's a commonality of what we call the controlled group, which is a greater than 50% ownership test, which is usually the case. It's usually 100% owned by the foreign parent. That money coming from the foreign parent is not treated as far as funding of the research. And as long as the boots are on the ground here in the U.S., it can and does qualify for the R&D credit. Well, wait a minute. My intellectual property is also going to be owned overseas, so I can't qualify, right? Wrong. As long as the controlled group, the greater than 50% ownership is met, it's all considered one big happy family. And so there's a lot of opportunities for foreign companies that do their R&D here, as well as, of course, domestic companies that do their R&D here. There's some ins and outs of it. There's something called the 280C election having to do with timing of deductions. We won't go into that. But the recent development with this alternative simplified credit, it came out in 2007, but a lot of people just didn't get the word. Well, in 2015, the IRS said, you know what, if you didn't claim any credit and the statute of limitations is still open for those years, we'll let you go back and claim the credit for those years. A tremendous benefit. So not only can you claim current R&D credits, but in many cases you can go back at least 3 years and claim past R&D credits. Well, what are the costs that we can claim? The lion's share is the wages. That's usually the big dollar amount. And this is for people who are either directly performing, directly supervising, or directly supporting the R&D credit. It's kind of a team concept. It was a long time ago that Thomas Alva Edison worked in his barn in Menlo Park, New Jersey, and created the light bulb all by himself. I know people will disagree with me whether that's entirely accurate, but I say it is. And but now it's a team concept. And so it's directly performing, directly supervising, or directly supporting the research. We can also claim supplies, usually consumable supplies, but there's a lot of costs that go into prototype developments. And the IRS in 2014 came out with more favorable regulations, and they said if you have a true prototype, for example, an airplane, you develop a new airplane, and to test it out, you had to create 5 of these prototypes. Well, you found out it worked. What did you do with the airplane? Well, we sold one. Does that mean that you can't claim the deduction and the credit for that cost? Nope. As long as you met the tests, the subsequent disposition of the prototype does not affect the credit eligibility. Contract research, we can claim 65% in general of contractors. They got to be here in the United States too, provided that we have a right to the results of the research. Why would you pay them if you don't have a right? And you're at risk whether the research is successful or not. There's also a little-known use of computer time-sharing costs, as well as basic research and energy consortia research. So as I mentioned, even if you don't do your R&D here, but you want to do your manufacturing here, there's another deduction. It's called the Section 199 deduction for domestic production activity deduction, and you get an extra 9% deduction over and above what you would already get, as long as your product is manufactured, produced, grown, or extracted in whole or in significant part, means a 20% test here in the U.S. So the bottom line is Congress wants you to do your R&D here, and it wants you to do your manufacturing here. Thank you, Mark.
Thank you very much. So one quick question for you. There's a lot of international controversy around patent boxes. And the way I understand the U.S. system, it doesn't require that the patents are owned in the United States as long as there's a controlled group. Is that correct?
That's true. That's true.
But in some countries, you have to have the patent physically located there in order to get tax preferences or credits.
Yeah, there's a lot of ins and outs with the patent box regimes, and there was also some legislative proposal, I'd say about 1.5 years, might have been 2 by now, to create what was called an innovation box, to create a similar type incentive to try and get the patents, this is not the correct terminology, but repatriated here, because Congress recognized that a lot of the intellectual property was being put offshore. I think it might have been the European countries, Belgium, that really was the leader in the patent box regime. The interesting thing about the innovation box proposal was there was a big trade-off involved, and that was that the Section 174 deduction, which generally allows you to currently deduct as opposed to capitalize your R&E expenses, that would have been done away. So with what Congress gives with one hand, sometimes they take away with the other.
It would seem to me also that these patent boxes would also distort the trade flows. I think Ireland is a major technology transferor according to U.S. data, but probably that's because of patent boxes or similar reasons.
That's probably the biggest reason, and there were some credits and incentives involved there. But absolutely, Congress is well aware of this citing of where the patents are going to be resident, and they're considering it, but everything takes time.
Last question is for the R&D credit. doesn't require a threshold. In China, you have to have 60% or more of your R&D.
Well, there are some thresholds with both the regular credit and the alternative simplified. There's something called a base amount. You have to get over that base amount. So, for example, the easiest example is the alternative simplified credit. The base amount is 50% of your prior 3-year average spend. So what's wonderful about that is even if I have a flat, very constant level of R&D spend, since the average is only 50% of those prior 3 years, usually I'll get some kind of credit. So, but there is a minimum threshold. There's also a minimum threshold for the basic research credit, no minimum threshold for the energy consortia, and no minimum threshold for the orphan drug credit.
Great. Well, thank you. I guess, Mike, I know you had something to add on Biddle and similar activities, and before we turn it over to the audience for a question or two, I thought I'd give you the opportunity.
Yeah, whenever I go overseas, I start out by telling people that Americans are not perfect, and we do have problems, and we're very good at solving problems once we reach a consensus about what our problems are. But I wanted to mention just 2 problems involving the role of government and the PTO in particular. The first is there are legal provisions in that apply today that actually deter the taking of licenses. And instead, they incentivize infringement activities. So what might that be? Inter-parties review was designed to eliminate poor quality patents, and that was a lofty goal, and apparently there were a lot of bad quality patents if you look at the data. But inter-parties is being used to attack strong patents and patents that where infringement has been alleged in federal district court. Alan Marco said good policy reduces transaction costs, and this is an area where transaction costs are being raised to the tune of about $1 million to $1.5 million for bona fide patent holders, including universities. If you're in a litigation with a large company, and there's nothing wrong with being a large company, they will take you to inter-parties, or they will say, we just don't want to pay that license fee. But if you would negotiate with us for a larger or for a lower license fee, maybe we could resolve the litigation. And I don't have a solution to this problem, but I agree with Alan that good policy reduces transaction fees, and we have an ongoing experiment where data can be collected and people can be interviewed. And this is we're not proffering a solution. We're simply saying that nonprofits get hurt by having to bear those fees, and Wisconsin can bear those fees because we do very well financially based on patent licensing. But there are universities around the country that don't have the tech transfer wherewithal that we have. The second area is one that just mystifies me. It's about sharing knowledge when government, when Biddle inventions occur, and it has to do with the American grace period. It was mentioned earlier by the USTR representative that we have a 12-month grace period in the TPP, but there's consensus that our grace period is either ambiguous or entirely broken. It's got 2 problems that are being written about in the blogosphere, but also in law review articles. One is that it doesn't provide for obvious variants of an invention. An obvious variant is somebody who reads an article by an inventor or PowerPoint saying, I have come up with a cure for Zika, or some other cutting edge invention, and then somebody can take that article and patent in a foreign country an obvious variant. And that would be prior art that defeats the patent. And then you sort of think, okay, so a cure for Zika cannot get venture capital in order to create a company. Or alternatively, which means it probably would have to go back to a government agency to fund, which is not a real good idea in a cost-conscious time. But the more important issue is that rather than the invention date, the disclosure, the publication, Section 103 of the Patent Act says you go to the filing date. So on a one-year basis, science moves very fast, and you're exactly right. It's collaborative and it's interdisciplinary. So universities, and I don't know about the government labs, have instructed their inventors not to publish. And this may catch some of you by surprise, but the patent, the concept of filing a quick patent application in the form of a provisional rules the day. And almost every major research university, and I'd like to get more data about this, and I'll probably try to get, maybe the PTO could help, just do a random survey of research universities and ask them what they have done regarding the patent education of their inventors. And I do know that most of the top 10 have told inventors, do not publish, do not disclose, do not share knowledge until we do a patent application. And it strikes me that that is a contradiction of our history as a country and the constitutional promise of promoting the progress of science and the useful arts. So these are just two issues to think about. We don't have solutions. Well, the latter grace period, there is legislation pending, but it doesn't look like it'll go anywhere.
Thank you, Mike. Maybe one or two questions before we turn it over to Dave to close out. If anybody has any questions. I know it's been a long day. Okay, Dave, are you ready? Sure, great. Thank you. Thanks to the whole panel.